time. My name is Melanie Jacobs, and I currently serve as the interim dean at Michigan State University College of Law, where I'm also a professor. I am so delighted to welcome you to our annual Kelley Lecture, and I'd like to give a little bit of background. And before doing that, I would like to offer the following. We collectively acknowledge that Michigan State University occupies the ancestral, traditional, and contemporary lands of the Anishinaabe Three Fires Confederacy of Ojibwe, Odawa, and Potawatomi peoples. In particular, the university resides on land ceded in the 1819 Treaty of Saginaw. We recognize, support, and advocate for the sovereignty of Michigan's 12 federally recognized Indian nations, for historic Indigenous communities in Michigan, for Indigenous individuals and communities who live here now, and for those who were forcibly removed from their homelands. By offering this land acknowledgement, we affirm Indigenous sovereignty and will work to hold Michigan State University more accountable to the needs of American Indian and Indigenous peoples. I think it's appropriate always to offer the land acknowledgement, but I think particularly as we talk about public service and we talk about ethics and so forth, it is even more appropriate. So I appreciate the opportunity to offer one. Frank Kelley was known as the people's lawyer and the people's attorney general, if you're not familiar with him. Unfortunately, Mr. Kelley died March 6th, so fairly recently. But Mr. Kelley holds the record for the longest continuous tenure as a state attorney general in the United States, 37 years. He was Michigan's youngest ever attorney general, and because he held the position for so long, he was eventually the oldest. He served under 5 different governors, both Republican and Democrat, and really transformed the office of Attorney General, creating an environmental division, consumer protection division, and criminal fraud division, things that we would all take for granted now, but weren't so common when he was serving. Mr. Kelley had a long relationship with MSU College of Law, and it was so wonderful in 2009 that he founded the Frank Kelley Institute of Ethics and the Legal Profession. It was founded in his honor. Every year, the Kelley Institute brings a leading legal thinker to the Law College to offer a public lecture, of course, and to engage. I said a few moments ago that I thought the land acknowledgement was particularly important, but I think of the moment we're in when there is so much distrust of each other, when I see such a fractionalized society wherein Democrats don't trust Republicans and Republicans don't trust Democrats, and suddenly party above people. And I think about someone like Frank Kelley, who served regardless of the party affiliation of governor, and yet somehow we've stepped back from that and we are not as trusting. I worry too as we read newspaper articles or watch news that our media has become so skewed that we can't always trust. And there are ways in which important facts are not always shared. Lawyers take an ethical oath. We are obligated to be truth seekers, truth tellers, and to pursue justice. And so I am so happy that we have the Kelley Institute. I'm so delighted that my colleague, the fantastic Professor Brian Gilmore, is currently the director of the Kelley Institute, and I turn it over to him to introduce our very honored guest today.
Thank you, Dean Jacobs. And I also want to thank Judge Levy's clerk, William Barcodes, who was very instrumental in making this happen. As you know, we're in Zoom, so there was a lot of logistics. And thanks Sally Rice, who also was making this happen today. And thanks to the Kelley family and everyone who's watching. I will keep this brief, and myself personally, I love brief introductions for myself. So Judge Judith E. Kelley was commissioned by Barack Obama, President, on March 14th, 2014, to serve as U.S. District Judge for the Eastern District of Michigan. She previously served as an Assistant United States Attorney in the Eastern District of Michigan from 2000 to 2014, and as Chief of the Civil Rights Unit in that office from 2010 to 2014. I will leave the rest of it to Judge Levy. Thank you very much for being our guest.
I like the idea of Judge Kelley because I had so much admiration for Frank Kelley. So I like that too. Thank you, Dean Jacobs. I so enjoyed the land introduction. I hadn't heard that before. So thank you for that. And thank you, Professor Gilmore, for your kind introduction. I'm so happy to be here today with you and with all of the students. And I see there's quite a few people here. I recently stepped away from teaching at the University of Michigan Law School, and I miss being with students on a daily or at least weekly basis. Students have always reminded me of the hard questions and required me to be my best self as a lawyer and a judge. Students require all of us to think carefully and to speak clearly. So thank you again for providing me this opportunity to spend some time thinking about hard questions and connecting with new students and new people. The title of my lecture today is Never Worked a Day in My Life. It's true. I try not to tell lies or encourage others to do so on my own behalf. So let me tell you that it is entirely true that I have never worked a day in my life. I have been fortunate to find work that is in harmony with my beliefs, where my work is simply a part of my DNA and the fabric of my life. I believe in taking breaks from things that are difficult and painful. Let there be no mistake about that. And I hope all of you who are joining us today do the same. Please take breaks from the hard stuff. Take good care of yourselves and enjoy yourselves no matter what. Humor is so important to all of us. So I encourage you to laugh, to play, and to try hard to do what's right and keep going with both the laughter and the hard parts. So I want to tell you a little bit about myself before I get to the subject that I'm going to focus on. It might be easier to understand why the recent period of judging has been so hard for me if you understand who I am first. This lecture series is about ethics, and we all face ethical dilemmas differently, and often the difference is based upon our life experiences. I'm also mindful that this topic, ethics and leadership, are areas of civic life that I have not studied, and I have no particular professional training or expertise in. But I have tried to live a life that is ethical and moral, and I have not found that particularly hard to do. Leadership is best left to others to evaluate. To the extent I have provided leadership, I'm thankful that someone sees it that way. I have faced a few obstacles in my life, some discrimination, some bias, and an incident of hate-based violence. So to the extent I've made my way through doors that were difficult to push open, I pledge to you today that I have and will hold them open for you to come through as well. I don't just like to thank those who helped me along the way, and that's so important to do, but I believe in taking the next step. I will hold the door for you, and I'm looking at our list of participants so that you can come through as well. But please know, I'm not unique in doing this. I know so many others who will do this as well. So I also want to thank you for joining us, particularly because you took a moment to do this when you didn't have to. And all of us are spending so much time in front of screens that I truly believe you have a bright future just because you're taking a moment to think about ethics and leadership. And even if one of your professors strongly encouraged you to attend today, I'm glad you're here, and I'm convinced that together we can weather this pandemic storm, no matter the losses you have experienced, and I know they are mighty. I'm here to open doors, to hold them open, and to listen to what you have to say, because I know I'll learn something valuable in the process. So back to our topic. I was introducing myself, and I'll do just a little bit more of that. I'm the daughter of a child survivor of the Holocaust, a German immigrant, my mother, and a survivor of the mean streets of Paterson, New Jersey, my father. I grew up in Bloomington, Indiana, where we were one of a very few Jewish families in the late 50s and 60s, something that's not true of Bloomington today. Throughout my childhood, I felt like I was somehow other, not like most of the other kids in the classroom or on the playground. I didn't suffer as a result of that. It was just a feeling I had. And perhaps most of us feel like that the more I think about it. I went off to college at a small liberal arts school in Ohio in 1976. There, in addition to getting a college education, to some extent at least, I came to understand that I'm a lesbian. I didn't suffer the way many gay people did then and still do today. That's why I often say that I'm also one of the very lucky ones. I already felt different from my peers, and I was used to that. I was also a skinny, awkward kid who was ticklish and giggly and not all that concerned about fitting in. I was not afraid of losing status or jobs or any of those things that so many people worry about. I had never felt confident that those things would be mine in the first place. So I arrived in Ann Arbor in 1978 to finish my college education. And somewhere along the way, I got distracted or drawn in a somewhat unusual direction. I became a community organizer for lesbian and gay rights, not as a paid position, but in all of the free time that I had or could manage to find. I had a job at the University of Michigan, and soon I got swept into union organizing and union leadership at the university. I spent 6 years as a full-time chief negotiator of the union that represents service and maintenance workers at the University of Michigan. But as time marched on and I grew older, I wanted to have a family. Back in 1984, I met someone I would fall in love with, have a non-legal marriage to in 1989, raise 3 children with, and finally marry in 2013 in Washington, D.C., before marriage equality became the law of the land and was possible here in Michigan. We're divorced now, and the judge who presided over our divorce told us what a privilege it was. We were his first gay divorce. And although it sounded a little odd, I totally understood what he meant by that. And I rejoiced with him that now me and my ex-spouse had the law to guide us through a difficult process. But back to our story. I went to law school, and after graduation, I had the enormous privilege of being hired to serve as a law clerk for a federal judge in Detroit, Judge Bernard Friedman, the judge who would ultimately strike Michigan's marriage law as unconstitutional, and whose case would be among the 3 that reached the Supreme Court of the United States and led to marriage equality throughout our country. I owe Judge Friedman a debt of gratitude for taking a chance on me. I was an older student, not the traditional candidate he was interviewing, and little did he know I was pregnant during the interview. I was hiding the little baby. I tried to communicate to Judge Friedman that I was a lesbian, but I don't think he picked up on it. I learned from Judge Friedman something I have never forgotten: to be open-minded, to welcome those who are a little different, and to take a chance on those less traditional candidates for jobs now that I'm hiring my own staff and law clerks. I went on after my clerkship to spend 14 years as a civil rights lawyer at the United States Department of Justice at the U.S. Attorney's Office in Detroit. Earlier, I mentioned to you that my mother was an immigrant and my father was from a family of meager means. I was raised with a critical eye about some of the inequalities in our country. But when I arrived at the U.S. Attorney's Office and went to court and stood before the judge on a case where I was enforcing our country's powerful civil rights laws, and I began with, "My name is Judy Levy, and I represent the United States of America," I became a patriot in some ways for the first time. I was proud to be an American and to be able to serve my country to make it a more fair and equal country, and ultimately a better place for all of us. So far as I was concerned, my work as a federal prosecutor bringing civil rights cases, fair lending, fair housing, police misconduct, disability rights, voting rights, and more, was the greatest honor I could ever imagine. So I have not forgotten our theme, and I truly believe I have never worked a day in my life. I've had the enormous privilege of spending my days working, yes, but engaging with and doing what matters to me, what I hope will make a positive difference in the lives of others, and what I also hope will make a contribution to our public lives together. So 8 years ago, as a result of the kindness and thoughtfulness of others, I was contacted by a young lawyer in Washington, D.C., who worked for a progressive, social justice-oriented organization. He said that his group was aware that there was a vacancy on the federal bench in Detroit, and they had done some calling around Southeast Michigan to some lawyers, and they came up with names to recommend for the position. This young man told me my name had come to their attention. I almost hung up the phone, thinking the call was for someone else. But a colleague and friend was in the office at the time, and she encouraged me to keep talking. The rest is now history, and I was nominated by President Obama to serve in the position that I now hold, and I was later confirmed by the United States Senate. So let me turn to the ethical issue I want to talk about today. I promise it won't be too much longer. I assumed this job that I now hold in March of 2014, just when our country seemed to have a national consensus that we are against mass incarceration, what we called mass incarceration. At that very moment in March of 2014, I became an incarcerator. I conduct civil and criminal jury and bench trials, and I take guilty pleas and sentence individuals indicted for federal crimes. Although Michigan does not have and never has had the death penalty, the federal system absolutely does. But the decision between life and death is left up to the jury. And in Michigan, to my knowledge, no federal jury has voted for death over life. I knew that if I were assigned a capital case, it would be incredibly hard, but I would not be the one making the decision to end another person's life. That was before the pandemic. About a year before we ever heard the word COVID-19, the United States Congress, in a remarkable show of bipartisan cooperation, passed a federal sentencing reform bill called the First Step Act. The idea was that more steps would follow the first one, but I'm not so sure that has happened. In any event, one small provision of the First Step Act was to provide for judicial review of something called motions for compassionate release. What this did was to provide every federal inmate an opportunity to apply for early release from custody where quote unquote extraordinary and compelling circumstances exist such that the defendant, the individual, cannot engage in self-care within the facility. What this means in plain English is that any defendant I have sentenced over the course of my now 7-year career could file a motion in court by sending a letter telling me that due to the pandemic, he or she is seeking compassionate release. I'm here to tell you today that even though the title of this talk is that I've never worked a day in my life, these decisions have been excruciating. Suddenly, I had a crush of motions filed and defendants telling me of the most horrible conditions of overcrowding, no masks, no hand sanitizer. In fact, the Bureau of Prisons had determined that alcohol-based hand sanitizer was too risky for a population with so many addicts. They might try to drink this viscous, horrible product that we've all come to rely on and appreciate. And the inmates told me that they were being forced to use their commissary money, if they had any, to buy soap. They were living in terror day and night. So as many people's jobs were slowing down or disappearing, mine was heating up to a degree I had never contemplated. Ultimately, after hours and hours of thought and research and contemplation, and with the help of my excellent law clerks, I came up with a framework to apply to the flood of motions that were arriving on the docket. I decided that if a defendant had one or more of the CDC risk factors, indicating that he, and the vast majority are male, could face severe illness or even death from COVID, then I would appoint a lawyer, have a hearing, remotely of course, and determine the outcome. But even if I determined that extraordinary and compelling circumstances existed that would warrant a reduction in sentence and immediate release, the law then requires me to examine whether the purposes of sentencing had been met, including whether the defendant was a danger to the community. When I tell you that these were excruciating decisions and still are, I mean that in the strongest possible terms. I have sentenced individuals who have committed some heinous crimes, and some who, due to their life experiences and circumstances, engaged in violence or drug dealing of fentanyl and heroin or other drugs at the highest level of the profession being the drug trade. Their conduct has put us all at tremendous danger. In those and many more cases, I have had to face the defendant, say to him that extraordinary and compelling circumstances would warrant his release, but that I am willing to risk his death because of an unknown danger to the community that could exist. I have made these decisions as carefully as I could make them, with no legal precedent to guide me, and with the certain knowledge that if I made the decision to deny a motion, I had to be prepared to live with receiving that individual's death certificate. I have granted many, many of the motions for compassionate release since March 13th of 2020. One of the individuals I released was murdered, and I have no idea why or by whom. He was a young man who I had grown especially fond of due to the several years I had presided over his case. He had worked very hard to become a positive member of his family and his community, facing the toughest of odds. And now he is gone forever. Should I have left him in custody with the underlying health conditions he had? Would young Roosevelt be alive today if I had denied his motion? Would it have been the right thing to do, regardless of the pandemic? And what about the white-collar defendants I have sentenced? Those individuals who have stolen millions of dollars from Medicare and Medicaid, and they have years left on their sentences. The calculation about whether they are a danger to the community is different from a violent offender. But to my mind, somebody who would steal $47 million from Medicare, and I had that case, which is designed to provide healthcare benefits to the vulnerable and aging in our society, is absolutely a danger to society. But how should I calculate that danger in the face of COVID? Are our healthcare dollars not more valuable and more important now than ever? And I have a defendant who set up a terrible scheme to steal a great deal of money from Michigan's unemployment fund. And he's a lifelong fraudster. Never as an adult had this man lived within the parameters of the law. And during the pandemic, unemployment insurance has been a lifeline for tens of thousands in our state. It needs to be protected from fraud now more than ever. But what about this man's underlying health conditions that could leave him vulnerable to severe illness or death if he caught COVID? What would you do in that case? He was not sentenced to death, yet he had 4 years left on his criminal sentence. In addition to waking up worrying about whether I would see a death certificate in my inbox from a defendant whose motion I denied, I also worry about waking up to news that a defendant I released has committed a new crime. I released a former gang member who had many years left on his sentence based on his medical conditions and the incredible number of COVID cases at the prison where he was being held. I set up strict conditions for his release, including substance abuse treatment and cognitive behavioral therapy. But put yourself in my shoes, and I'd be very interested in what you would have done in that situation. In addition to these motions, last April, I was randomly assigned a proposed class action by individuals in ICE detention, awaiting deportation at a time when travel was essentially non-existent. These individuals had unbelievable health problems, and they were not in custody for committing a crime, but merely for arriving in this country without documents or overstaying a visa, sometimes decades earlier. So punishment was not a part of the calculus for those plaintiffs. Ultimately, I've released about 50 ICE detainees at medical risk from COVID, and 2 have absconded. Was that worth it? Could I have known that would happen? Would you have known? And would you have kept 50 people in custody to avoid releasing the 2 who absconded? These are just a few of the questions that judges face every day. And of course, we face these questions when there isn't a pandemic, but not with the possibility of death or lifelong medical problems, hanging in the balance. The intensity and urgency of these decisions has been very difficult to sustain. But I know that the moment I don't find these decisions as ethically and morally challenging as I do, it will be the moment I should not be in the job I now hold. And I can promise to you that I will not continue to make these decisions unless they continue to be this difficult. One more thing about the law, shifting for a moment. As a country, we're watching a remarkable trial, People versus Derek Chauvin, unfold in Minneapolis. I've been reading about it each evening. Though I've never seen the 9-minute video at the center of the trial. Our daily lives are often filled with violence and pain, and my job brings me into close proximity to those things. As a result, I choose not to watch people suffer if I'm not required to do so. I value life, and I hold it so dear to my heart that I simply cannot look at violence when I'm not required to do so, and particularly violence against Black and Brown people. I encourage you to follow the trial, to think of what you would do as the prosecutor, as the defense lawyer, as the judge, and as the jury. Think carefully, and I encourage you not to be afraid to see things differently than those around you. That's the beauty of our system. In fact, I believe that our legal system is among the greatest legal systems in the world. It's not without its failings, and in some ways, very big ones. But it is a system that I believe has bound our country together from its earliest days. Our former Attorney General, Eric Holder, who I had the pleasure of meeting on many occasions, said it so eloquently. He framed it this way about our legal system. He said that our legal system embodies the values this country aspires to: equality, opportunity, and justice under law. And that here in the United States, we have turned time and again to our legal system to solve problems, social, political, and economic, and to hold individuals and institutions accountable for their conduct. Our justice system has been called upon to address issues as diverse as slavery and segregation, voting, violent crime, equal rights and equal justice, enforcement of contracts, placement of children as between parents and institutions, and much more. But our legal system is only as good as those whose hands we entrust it to. And our legal profession asks a lot of lawyers. Lawyers are required to keep the confidences of their clients, to maintain the secrecy of what is learned in the grand jury if you're the prosecutor, and to zealously represent your client in all instances. You're called upon to be creative, yet stay within the framework of the Constitution and the laws that you're either enforcing or defending. A tension that's not always easy to live with. In virtually all sorts of legal practice groups, from corporate transactional work to public interest test case litigation, long hours are required, and it can be hard to achieve a balance between work, home, family, and caring for yourself as an individual. I hope that the remarks that I've offered today will provide you with some opportunities to discuss some hard questions and reflect upon the course you wish to take as a lawyer. And please consider searching for work where you will never work a day in your life. Thank you, Professor Gilmore and Dean Jacobs, for inviting me to deliver these remarks.
And thank you, Judge Levy, for that very nice talk. I think we probably will have some questions. I don't know if Melanie has a question. I'll have maybe one, and then we can throw it out to the audience, I assume.
So please feel free, Professor Gilmore, to ask your question. For all of you who have joined us, I had noted in the chat, please go ahead and post your question in the chat, and I'm happy to moderate. So, and let me just add my thanks, Judge Levy, for a great presentation. And I think it is such an important aspiration. The work we do is hard, and the examples you gave of such challenging, difficult decisions that you've had to make, but to still feel great about your choice of career, your choice of profession and what you do, it's not always easy to find. So I really appreciate you sharing your reflections. So
thank you.
So Professor Gilmore, I turn it to you for your question, and then please, participants, start typing your questions so that we can share them with Judge Levy.
I guess my question goes back to things I read. I read an article you wrote about in the Urban Lawyer. I mean, I don't know how old it was, but it was like 2004 or something like that. And then I also saw your talk you did as well. And this question goes to two things you said. One thing you said in the Urban Lawyer, you were talking about these small cases that you were working in when you were doing the civil rights work, and they had like small judgments and things like that. And then also in the talk you did, you talked about how you needed to before you sentence people, you needed to talk to them, not their lawyer and not the prosecutor. And the consistent line I saw there was, you seem to be very interested in specifics as opposed to abstracts, abstract kind of facts about things. So I was just wondering, what do you think in your background growing up, maybe it was in Bloomington or whatever, what do you think has molded you as that kind of judge who's, and also, you know, you were an advocate on part of that, but just as a legal professional, you seem to be very interested in the person, shall we say.
That's a really interesting question. And I tend to think that one of the benefits that I had is something that I referenced today, which was growing up, the teachers would ask, is anybody, I just vividly remember this in 3rd grade and then again in 5th grade, during Passover or whatever, asking, is anybody in the classroom Jewish? And there was me and Deborah Weinberg, and the two of us would put our hands up and people would stare at us. And just growing up feeling just a little bit different from other people just helped me, I think, in a positive way, so that peer pressure just has not had that great of an impact on me. So I've been able to develop my judgeship just a little bit independently as well, so that I may do things a little bit differently and not, also it helps that I'm sitting in Ann Arbor, that there aren't a lot of people stopping in the courtroom. There's not a lot of judges stopping in the courtroom. I've just been able to develop a rapport with people who come in the courtroom because it just matters so much to me. I guess I'm not sure I have a good answer to your question. Here's somebody says they would, oh, go ahead.
Yes, so we have 2 questions. I was going to give you the second one first, which is, are you able to share a situation in which an attorney who appeared before you was found to have violated the rules of professional conduct? And are you able to give a little bit of background of how this situation was resolved? And then we have another good question about the emergency manager. So maybe we could start with a more general and move to a more specific.
Well, I have had a handful, a very small handful of situations where lawyers have not been able to keep their work within the rules of professional conduct. One of them happened recently, covered in the newspaper. It was a lawyer in Flint, Michigan, who sent out just under 300 solicitation letters to other people's clients in the Flint water litigation. And so that came before me for a public hearing. And I issued a decision about the rules of professional conduct that were at issue in the case. And it was I think it was an important development in the case to generally communicate to the public that the lawyers in this case will be held to their professional responsibilities. They will be required to meet those responsibilities throughout the case. Their clients it's just too important to the people of the city of Flint and to the defendants that the case be handled carefully and professionally. So yeah, I did come across that situation very recently. Generally, every now and then I'll get a case where a lawyer is kind of on both sides of an issue, and I'll issue a little show cause or request for briefing on how you're going to represent both clients in this case and make sure that there isn't a conflict of interest that's going on. I have my ear to the ground in all of my cases for any possible violation of the rules of professional conduct, just because it can destroy the case and it has to start over. And no one wants that in a civil or a criminal case. So it's really important for the judge to stay very knowledgeable on the rules of professional conduct. Also, I would encourage students as you develop your legal career to find some trusted advisors, professors who you can call 5 years, 10 years, 20 years later when you face an issue that you're uncertain of. Call for help. Don't try to do it yourself. I do that. As an AUSA assistant U.S. attorney, I was the most frequent caller for the ethics officer and the professional responsibility officer in the office, because there's a constantly issues that push you to the edge of your responsibilities. So I really encourage you to find trusted advisors and stay connected to them.
I really appreciate that particular piece of advice. I think so often individuals think as soon as they graduate, right, that it shows weakness
Oh,
or a lack of preparation to ask questions and so forth. And actually, it shows tremendous strength and good judgment to
yep.
solicit those opinions. So it's great that they hear that from you. Thank you.
Yeah, and the law firm's going to have, if it's a law firm, they're going to have a general counsel. They're going to have someone designated to take those calls. They want to hear from you because it protects the firm, it protects the clients. So I can't tell you how once a week I would come up with an issue that I would be uncertain of in terms of the rules of professional conduct. And I ask for help. So,
So we have, as I mentioned, another question related to, and I'll just read it. The Michigan Emergency Manager Law requires the city of Flint to hire an attorney to defend the emergency manager appointed to make decisions for the city, resulting in the water crisis. This meant the city had to defend a state official, but did not have an attorney representing its own interests as a city. Is that fair? Should the city have had its own legal defense separate from defending the emergency manager, especially to have its own counsel participate in settlement talks?
wow. Well, here's one thing. As a judge, I have to follow the judicial canons of ethics. It's very similar to the rules of professional conduct. And one of the things that I'm prohibited from doing is commenting on a pending legal matter that's up for on appeal or up for a decision. I don't really think that question is entirely would cause me to go over the line on that. But I made a decision in the Flint water litigation early on that the actions of the emergency managers legally, and it's in a case called Sherry Girton versus Snyder et al., that legally the emergency managers at the time that they took the actions they did were the city, that they were city officials, even though they had been appointed by the state. And that was affirmed by the Sixth Circuit Court of Appeals. That issue was taken up on appeal by those individuals or by the city of Flint. And so the city of Flint has its own lawyers in the litigation who are defending both decisions of the city and the emergency managers, and the Court of Appeals thought that that was the correct decision. So I don't know whether it's fair or it's right or wrong. I didn't come up with this idea of emergency management. I'm just sort of stuck with the legal framework that it created. So I appreciate the question. I understand the impulse behind it. And it has been a complicated legal issue.
So you were really very gracious and candid sharing your background, your experiences, some of your views. And so a good question came in that to what extent, while you were working with the Department of Justice, did you have to then represent the government or represent a side or issue that didn't comport with your own personal beliefs, your own personal ethics? And then how do you balance that when you have a clear sense
Mhm.
personally of what you want to do, but of course you're representing the United States? How are you able to manage that?
For the most part, I was able to be bringing civil rights cases on behalf of the United States, and there was no conflict there internally for me. At the beginning of my time at the U.S. Attorney's Office, I was doing defensive civil litigation. I was defending the INS, Immigration and Naturalization Service, before we had Department of Homeland Security, defending the post office in employment discrimination cases, and so on. And what I found in those cases is that there were good defenses in cases. There were legitimate good defenses that I felt strongly about, actually, that the beauty of representing the United States is that when the government is liable, in my experience, we were authorized to settle cases. We didn't have to fight cases that where there was liability, where as a lawyer, we could advise the client, they got us here. The postal truck ran into the person and injured their shoulder. I've had an expert take a look at the shoulder. It really is injured. We need to pay. So it's such a privilege to represent a client that you can believe in and that will settle cases where liability is shown. So there was one case I had where I thought I might have sort of enough of an internal conflict, and I went to my supervisor and said, you know, I want to take the plaintiff's deposition, but if it turns out X and Y are true, I'm not sure I can defend this case. I took the deposition, and oh my God, not only X and Y were a big old lie, I became so committed to the case, and it was just dismissed, you know, a week after the deposition because the plaintiff, it was all wrong. So it never came to be where I had to ask to get off the case, but I was prepared to ask if I had to. So.
Perhaps a little bit related, one of our participants has asked if you might share thoughts on how you feel the ethical obligations of a judge relate to that in the attorney role. So more specifically, do you feel that there are major differences or similarities? As a judge, do you have an obligation to find the truth at all costs, similar to an attorney, or is your obligation constrained in some way?
That's a good question. I am constrained by the adversarial process. The idea is that if lawyers fulfill their professional duty to zealously represent their client, that process will bring to the judge as with respect to the law and the jury with respect to the facts, it will bring them out such that the proper decisions can be made. That's when everything's functioning as it should. And everything does not always function as it should. It's not always a fair fight. One lawyer is often significantly stronger than the other lawyer. Or perhaps the case isn't as good on one side as it is on another. And what I want to do is get the law right, no matter what. So along with the help of my law clerks who work really hard, we research the law on occasions where lawyers have not brought us the most important case or have not done the kind of research that we'll take the time to do to make sure the decisions we make are based firmly in the law. But the facts, we don't have the ability to explore new facts. We don't take depositions. We don't direct that a deposition be taken. The development of the facts is in the hands of the lawyers. And so we're limited by that. And hopefully by zealously representing your client, we get the facts to the jury, or if it's a bench trial, to the judge, or a motion to suppress, or in a criminal case. But I will, when witnesses are on the stand with a jury, I have a personal philosophy that I should not ask them questions other than if I hear a witness use language that I know might be unfamiliar to the jury. I might say, could you explain extemporaneous, or could you explain what you just said? I might ask some questions like that, but I won't delve into the prosecution, the defense, the plaintiff or the defendant in a civil case, into the substance with a witness. That's the lawyer's responsibility, and the clients have selected their own lawyers. So, yeah. One exception is if there is a criminal case, and I believe that we might be heading into Sixth Amendment hot water, where a defendant may not be getting the unconstitutionally ineffective assistance of counsel. I will make inquiries on the record into that, and if necessary, remove the lawyer or call in backup counsel and things like that, because that's a different area where somebody's liberty is at stake, and I have to safeguard the constitutional rights of the defendant.
As you were speaking, Judge Levy, I was thinking about a film I watched recently. I believe it's nominated for an Academy Award this year, The Trial of the Chicago Seven. And I was thinking about Professor Gilmore. I don't know if you saw it, you're nodding. I mean, I realized you'd be familiar with the actual trial, but in the film, the way in which the judge behaved, right? It's completely antithetical to what you just described.
Yeah.
Between physical restraints, which were just horrific, and it's like its own separate horrible thing that the judge did, but just the way in which the judge didn't seem to have an interest in a pursuit of justice or pursuit of truth. So, I mean, it goes a little bit to the question I think Casey was asking, but I'm curious, of course, that was a different moment in time. Do you think that there have been changes to the judiciary over time in terms of the way, and is judging different now in 2021 than in 1990, 1970, 1950?
It's interesting. I saw that movie too. Even though I was alive at that time, I was younger, I was aware it was going on, but I had no idea that the judge had behaved the way he had. So I am glad that slice of history has come out in the light. And I encourage everybody to take a look at the movie. I do feel as if judges we are getting training in unconscious bias, something that is new to the judiciary. We are getting trained in restorative justice. I just last week attended 2 sessions that the Federal Judicial Center put on. Each one had about 300 participants from probation, pretrial, and judges, looking at ways to avoid criminal prosecute, diversion programs so that individuals do not go through the criminal justice system. And that's something that I think 10 years ago, 20 years ago, my job is to hear the criminal cases and sentence people. And as opposed to my job is to help people reconcile with one another and to problem solve. Personally, I look at my job as one of being a problem solver, and we wouldn't have lawsuits if people could solve their problems on their own. And so question is, what's the best way to solve this problem? Is it a jury trial or is it a settlement conference? Is it some other sort of process that could be used? So I do think that there's a lot more literature out there and a variety of training opportunities for judges that just didn't exist in the past. So.
Professor Gilmore, I see that we are we're getting close to the end of our time. So I wanted to give you the last word, last question.
Oh, I get the last question. So I guess my question, a very simple one, is you probably have had jury trials since you started. I just wanted to know,
Oh, yeah.
Do you feel that people still take that civic duty as serious, and what is the state of the jury trial today?
Yeah, I've had more criminal jury trials than civil, but I've had a good handful of civil jury trials. And I will tell you, number one, the jurors take these cases as serious as a heart attack, as my family, we always say it's as serious as a heart attack. They work hard, they stay focused, they stay awake. My job is to make sure they're awake, and I have a little technique. Oh, it's time for a stretch break if I see somebody's eyes getting heavy. But first of all, the jurors, I'm just so encouraged by the hard work of the jury. The jury questions that come out during deliberations are sophisticated. I'm just tremendously impressed. And just because I'm sitting in Ann Arbor, I don't get, University of Michigan faculty members. It's a broad cross section, Wayne County, from 5 counties in the area. So I'm really impressed by that. And lawyers work hard. I had a 2-month trial right before the pandemic. Everyone's exhausted but working incredibly hard. So there are not as many jury trials as I think people think there should be or have been or something like that, because the costs of them are so expensive for clients. But when they take place, we all work really hard.
Yes, and I think Professor Pachillo has a really quick follow-up, and it's just in evidence he would like to hear if you believe that the jurors follow your instructions.
The limiting instruction, that's such an important question. The Sixth Circuit tells us that we are, in the Supreme Court, that we're to assume that jurors follow the judge's instructions. I tend to think, if it's a limiting instruction, if something inflammatory just came out and I say, oh, disregard that, we're all human. But I have seen jurors send me questions, juror questions about details in the jury instructions. A definition of the 4th element of a cause of action. And I give all of the jurors a copy of the jury instructions, not just one in a binder, so that no one can hog those instructions. Everyone can work through them. So I have my suspicions that some limiting instructions would be very hard to follow. I also let jurors take notes during the trial, as long as neither party objects to taking notes. And so I hope that helps jurors to be able to keep up in a longer trial with what's gone on, so that they can follow the instructions when it's time. Yeah, that's a good question.
Okay, thank you very much for everyone for attending. Thank you, Judge Levy, for an outstanding talk, for this institute, which we have great respect for. I feel honored to be able to serve as the interim director. but it's been very nice. And this is the second one since I've been here. And thank you to everyone.
Great. Well, thank you. Take care, everybody, during the pandemic. We're gonna get this thing done.
Kudos to you, Professor Gilmore, for bringing us such a spectacular guest. And thank you so much, Judge Levy. This was wonderful.
Sure. Thank you. Bye.